Hello dear students, today we are going to discuss public interest litigation. Before going through this topic, first let's have a look on its objectives. First, the meaning, nature and scope of public interest litigation. Second, locus standi. Third, the abuses of public interest litigation. And fourth, to discuss few cases regarding public interest litigation. Dear learners, we know that it is the machinery of justice that breathes life into all the rights. Therefore, it is very important that justice delivery system should be accessible to all. The importance of this principle was amply highlighted by Justice Brennan, Associate Justice of the U.S. Supreme Court, when he cautioned, I quote, "Democracy's very life depends upon making the machinery of justice so effective that every citizen shall believe and benefit by its impartiality and fairness. No democracy which has adopted socialism as a pattern of its socio-economic structure can survive unless it is based on the rule of law, and the rule of law postulates that everyone, irrespective of his means, should be able to avail the machinery of justice." Unquote. Public interest litigation in this respect has proven to be one of the most potent tools for availing the machinery of justice for the poor and downtrodden majority. Dear students, let's discuss now the meaning, concept and the nature of public interest litigation. The public interest litigation has not been defined in any statute or act. However, public interest in Black's Law Dictionary is defined as something in which the public, the community at large, had some pecuniary interest by which their legal rights or liabilities are affected. The expression litigation means a legal action including all proceedings therein, initiated in a court of law with the purpose of enforcing a right or seeking a remedy. Therefore, legally speaking, the expression public interest litigation means a legal action initiated in the court of law for the enforcement of public interest or general interest in which the public or the class of the community have pecuniary interest or some interest by which legal rights or liabilities are affected. This concept of public interest litigation had its origin in United States of America. The courts in the United States developed the concept of public interest litigation while adjudicating those matters wherein public interest was involved. According to Justice V.R. Krishna Iyer, public interest litigation is a process of obtaining justice for the people and of voicing people's grievances through the legal process. The aim of public interest litigation is to give to common people access to courts and obtain legal redressal against injustice done to them. Justice P. N. Bhagwati opined that public interest litigation is not in the nature of adversary litigation but is a challenge and an opportunity to the government and its officers to make basic human rights meaningful to the deprived and vulnerable sections of the community and to assure them social and economic justice, which is the signature tune of the Constitution. The government and its officers must welcome public interest litigation because it would provide them an occasion to examine whether the poor and the downtrodden are getting their social entitlements or they are continuing to remain victims of deception and exploitation at the hands of strong and powerful sections of the community. Through public interest litigation, the courts merely assisting in the realization of the constitutional objectives of social and economic justice. Enunciating the broad aspect of public interest litigation, Justice Bhagwati observed in the case of S. P. Gupta versus Union of India that whenever there is a public wrong or public injury caused by an act or omission of a state or a public authority which is contrary to the Constitution or the law, any member of the public acting bona fide and having sufficient interest can maintain an action for redressal of such wrong or public injury. The range and the scope of the public interest litigation are vast, as it is a mechanism to agitate any socio-economic public issue before the court which can be brought within the legal and the constitutional mold. Now, dear learners, let's discuss essentials of public interest litigation. There are three new elements incorporated in public interest litigation. First, liberalization of law relating to locus standi. Second, adoption of simple procedure in entertaining public interest litigation petitions. And third, expansion of the meaning and scope of Articles 14, 21 and 32 of the Constitution. Certain essentials were laid down by Justice Bhagwati in the case of S.P. Gupta versus Union of India. First, there must be a legal wrong caused to a person or to a determinate class of person on whom burden is imposed in violation of law or without legal authority. Second, the wrong must arise from violation of any constitutional or legal right. Third, the wronged person or determinate group of persons must be unable to approach court for relief by reason of poverty, helplessness, or social or economic disability or socially or economically disadvantaged position. Fourth, if these conditions are there, then any member of the public can seek judicial relief for the above wrong. Fifth, but the court should be anxious to ensure that the person initiated bona fide legal proceeding to get redress for a public grievance and not to pursue personal gains from malicious motives. Dear learners, now let us understand the constitutional provisions. The new and liberal interpretation of the fundamental rights found in Part 3 and the directive principles of state policy in Part 4 of the Constitution of India gave the present movement for public interest litigation a radical thrust. They are drawn from the revolutionary documents like the American Bill of Rights and the Universal Declaration of Human Rights. Article 32 and 226 of the Constitution gave power to any citizen to move the Supreme Court or High Courts whenever there is an infringement of a fundamental right. Article 32, Clause 1 guarantees the right to move the Supreme Court by appropriate proceedings for the enforcement of the fundamental rights. Article 32, Clause 2 states that the Supreme Court shall have the power to issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari, whichever may be appropriate for the enforcement of any of the rights conferred by Part 3 of the Constitution. Article 226 states that notwithstanding anything contained in Article 32, every High Court shall have power throughout the territories in relation to which it exercises jurisdiction to issue to any person or authority, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari, or any of them for the enforcement of any of the rights conferred by Part 3 of the Constitution, that is, fundamental rights, and for any other purpose. The Supreme Court and the High Courts have equal powers to issue writs, orders or directions for enforcement of the fundamental rights. The Supreme Court expanded the meaning and scope of the fundamental rights in favor of the weaker sections of society. The meaning and scope of Articles 14, 21 and 32 of the Constitution were given a wider interpretation in favor of the weaker sections. The right to life was interpreted to mean a right to livelihood as well. Similarly, the right of equality under the law guaranteed by Article 14 was interpreted to provide a right against executive and administrative arbitrariness in any decision making. Dear students, now let's discuss locus standi. For enforcement of any legal right, the traditional rule is that the right to move to court is available to the person whose right is infringed, or in other words, it is the only person wronged who has the right to move to the court for its redress. This principle is known as the doctrine of locus standi, which means that only a person whose rights have been violated have the standing to move to the court. This doctrine was solely aimed at protecting the courts from vexations and frivolous litigation. The Latin words locus standi signify the legal right of a person to file a suit or conduct a litigation in a court of law. According to the traditional Anglo-Saxon concept of locus standi, means only the person whose rights were violated could sue for judicial redress. No one could file a petition in the court on his behalf. This doctrine was evolved in an era when the courts were mainly concerned with the rights of the individual. The old doctrine of locus standi had not been found to be adequate to meet the needs of a developing society. In the new age of collective rights, it has been felt that the traditional interpretation of locus standi should be changed to bring justice within the reach of the poor masses. According to the new interpretation given to this doctrine by the Supreme Court, when the rights of an individual or a class or persons are violated, and if by reason of poverty or disability they cannot approach the court themselves, any public spirited person or institution acting in good faith and not out of vengeance can move the court for judicial redress. The strict rule of locus standi was first relaxed in the case of S.P. Gupta versus Union of India. The 7 judges Constitution bench by a majority ruled that any member of the public acting bona fide and having sufficient interest in instituting an action for redressal of public wrong or public injury could move to the court. The court will not insist on strict procedures when such a person moves a petition on behalf of another or a class of persons who has suffered legal wrong and they themselves cannot approach the court by reason of poverty, helplessness or social backwardness. It is therefore well established that where a legal wrong or a legal injury is caused to a person or to a determinate class of persons by reason of violation of any constitutional or legal right, or any burden is imposed in contravention of any constitutional or legal provision or without authority of law, or any such legal wrong or legal injury or illegal burden is threatened and such person or determinate class of persons is by reason of poverty, helplessness or disability or socially or economically disadvantaged position unable to approach the court for relief, any member of the public can maintain an application for an appropriate direction, order or writ in the High Court under Article 226, and in case of breach of any fundamental right of such person or determinate class of persons, in the court under Article 32, seeking judicial redress for the legal wrong or injury caused to such person or determinate class of persons. Regarding locus standi, the Supreme Court in S.P. Gupta versus Union of India, popularly known as Judges Transfer case, ruled that any member of the public having sufficient interest can approach the court for enforcing constitutional or legal rights of other person and redressal of a common grievance. In the case of Palampur Bar Association versus High Court of Gujarat, the Gujarat High Court upheld the locus standi of Bar Association to file public interest litigation, challenging the establishment of court of joint district and judge and additional session judges at a particular place. The High Court observed, since lawyers are both officers of the court and persons having fiduciary relationship with consumers of justice, they may ventilate their grievances in relation to the establishment of courts and conferment or curtailment of powers of the court. Judiciary is playing a very prominent and promising role in protecting the public interest. Some of the landmark decisions through public interest litigation, including the case of Sheila Barse versus Union of India. Sheila Barse highlighted the inhuman treatment meted out to juveniles. The petition prayed for the release of 1,400 children detained in the jails and for speedy trials of juvenile under trials. It also requested the court for an uniform juvenile justice system. Public interest litigation that it was a direct outcome of the exposure of this issue through media, and a Juvenile Justice Bill was passed in 1986, which laid down a uniform legal framework and guidelines to the states to try juvenile delinquents. The decision to shift children from jails to observation homes providing educational and vocational training facilities was also taken at the state level. In the case of Bandhwa Mukti Morcha versus Union of India, the Supreme Court entertained a matter concerning release of bonded labour, raised by an organisation dedicated to the cause of release of bonded labour. The court rebuked the state government for raising a preliminary objection to start an inquiry by the court into the matter. Dear learners, now let's understand custodial violence. In the case of Sheila Barse versus State of Maharashtra, the Supreme Court's historic judgment that deals against the custodial violence in prisons. This resulted in an order facilitating separate lockups for women convicts in order to shield them from further trauma and brutality. Now, we shall discuss another aspect, abuses of public interest litigation. Public interest litigation is a challenge and an opportunity to the government officers to make basic human rights meaningful to the deprived and vulnerable sections of the society and to assure social and economic justice, which is signature tune of our Constitution. There have been several instances in the past when the Supreme Court has deprecated the tendency of petitioners to approach the courts by way of public interest litigation to ventilate personal grievances or gain publicity or with some ulterior motives. Despite this, a public interest litigation titled State of Uttaranchal versus Balwant Singh Chofal was filed under Article 226 before the Uttaranchal High Court, challenging the appointment of Advocate General of the state on the ground of age, terming the petition as an abuse of process of court. The petitioner was visited with the cost of Rs 1 lakh. The court also issued the certain directions in order to preserve the purity and sanctity of public interest litigation. First, the court must encourage genuine and bona fide public interest litigations and effectively discourage and curb the public interest litigation filed for extraneous considerations. Second, instead of every individual judge devising his own procedures for dealing with the public interest litigation, it would be appropriate for each High Court to properly formulate rules for encouraging the public interest litigation and avoidance of oblique motives. Third, the court should prima facie verify the credentials of the petitioner before entertaining a public interest litigation. Fourth, the court should be fully satisfied regarding the correctness of contents of the petition before entertaining a public interest litigation. Fifth, the court should be fully satisfied that substantial public interest is involved before entertaining a petition. Sixth, the court should ensure that the petition which involves larger public interest, gravity and urgency must be given priority over the other petitions. Seventh, before entertaining a public interest litigation, the court should ensure that a public interest litigation is aimed at redressal of public harm or public injury. The court should also ensure that there is no personal gain, private motive or oblique motive behind filing the public interest litigation. However, the court should also ensure that the petition filed by the busybodies for ulterior motives must be discouraged by imposing exemplary costs or by adopting similar novel methods to curb frivolous petitions and the petitions filed for extraneous considerations. In the case of Ronak International Limited versus IVR Construction Limited, it was observed that courts must satisfy that the party bringing the public interest litigation is litigation bona fide for public good. It should not be merely a cloak for attaining the private ends of a third party or party bringing the petition. In the case of Ajay K. Agarwal versus Shri Manmohan Singh, public interest litigation had been filed by the petitioner under Article 32, raising the grievance regarding atrocities committed by Delhi police at the innocent people and the manner in which they have been dispersed by force in the midnight at Ram Leela Maidan in furtherance of the permission granted by the concerned authorities. The petitioner produced before the court copies of some prominent newspapers which depicted the sad state of affairs and brutality committed by the police. The Supreme Court, by an order dated 6/6/2011, dismissed the same on the ground that the petition had been primarily filed for granting publicity. Despite this, the court was convinced that the matter was serious as the issue related to the police brutalities or atrocities on the innocent people. Why not then the court ignore the motive of the petitioner as has been done in many cases in the past? In order to salvage the situation, by the same order, the court took the suo motu cognizance of the matter and issued notices to various authorities to show cause and file their personal affidavits explaining the conduct of police authorities. The Supreme Court and High Courts have defined the elastic contours of the unique jurisprudence of the pill. The courts have sought to maintain a delicate balance between the traditional litigation by intervening only in those matters that are genuine in public interest and pertain to protection of fundamental rights of the disadvantaged and vulnerable sections of the society. Public interest litigation is not a pill or a panacea for all wrongs. There have been in recent times increasingly instances of abuse of public interest litigation. Therefore, there is a need to re-emphasize the parameters within which the public interest litigation can be resorted to by a petitioner and entertained by the court. Now, dear students, let's understand the process of procedure to file pill. There are least technicalities involved in filing a writ petition involving public interest. No person is bound to follow all the prescribed procedures and formalities of a writ under Article 32 when litigation involves public interest. According to Supreme Court, procedure is but a handmaiden of justice, and the cause of justice should never be allowed to be wasted by any procedural technicalities. The court would therefore unhesitatingly and without the slightest qualms of conscience cast aside the technical rules of procedure in the exercise of its dispensing power and treat the letter of the public-minded individual as a writ petition and act upon it. The Supreme Court has enormous power under Article 32 to enforce fundamental rights of the citizens. In the case of Shri Ram Foods and Fertilizer Industries, the Supreme Court held Article 32 does not merely confer power on the court to issue a direction, order or writ for the enforcement of the fundamental rights, but it also lays a constitutional obligation on this court to protect the fundamental rights of the people, and for that purpose this court has all incidental and ancillary powers, including to forge new remedies and fashion new strategies designed to enforce fundamental rights. It is in realization of this constitutional obligation that this court has innovated new methods and strategies, particularly for enforcing the fundamental rights of the poor and disadvantaged who are denied their human rights and to whom freedom and liberty have no meaning. Dear learners, from this whole discussion, it becomes clear that public interest litigation is the result of judicial activism. It is now well established that public interest litigation is a remedial jurisprudence where the court transcends the traditional judicial functions of adjudication in its endeavour to protect the fundamental rights of the disadvantaged sections of the society lacking access to the courts. The Constitution of India in Part 3 guarantees fundamental rights to every citizen. The exercise of these rights is necessary for his overall development. The state has an obligation to enforce these rights. When these rights are violated by the state and its agencies, citizens have the right to take the matter to the constitutional courts for enforcement. The basic reason for the growth of public interest litigation in India is bureaucratic unresponsiveness to public needs. No effective mechanism has been established as yet for the redressal of public grievances against the administration. The result is that any person having a grievance against an administration has no alternative but to take recourse to the courts for the redressal of such grievances against the administration. Public interest litigation has flourished in India because of lack of any sense of accountability and responsibility on the part of government. It has been rightly observed that public interest litigation, if carefully and prudently used, the public interest litigation has great potential in correcting administrative wrong, but if liberally and indiscriminately used in all kinds of cases, it may turn into an engine of destruction. With this, we conclude today's topic on public interest litigation. Hope you have enjoyed this session. For now, it's time to say goodbye. Stay blessed.